What?
Yes, I'm here. Hey, Nour, how are you doing?
Good. How are you?
Okay. Thank you very much for having us today. This is Juan Carlos Brando, and thank you so much for this show with the attorney Nour Chammas. And well, we are ready to go with the questions. How are you doing today, sir?
Doing well, thank you.
Okay, we have a bunch of questions coming in from our audience, and one of the things that people are asking is uh, what's going to happen with the border in the southern border is a lot going on, but many decisions have been made in the last few days, like asylum not being able to be filed at the border, at the southern border. So, what does this mean? That can people still file for asylum?
Yeah, so people have a right to file for asylum. Um, However, as was the case with the new policy from the Biden administration, which began a couple months ago, is they're trying to control the amount of people that are able to get through the southern border. And so they've stopped accepting people entering, of course, at legal ports of entry. Whenever they reach a certain limit. So if they reach a certain threshold, more than a certain number of people coming in, then they are suspending anybody's entry for a couple weeks. So it makes them unable to come in and file asylum at the port of entry. Now this is something that's probably there's gonna be a lot of debate going back and forth because under the law, you are supposed to have a legal right to be able to request asylum in the United States if you fear persecution in your country. Also, if you get through the border illegally and come in, you can file for asylum with USCIS. Whereas people coming in at an actual port of entry are being prevented from doing so if the numbers reach a certain threshold, making it appear like it would be easier if you just cross the border illegally rather than presenting yourself at a legal port of entry. So at this point in time, everything is really up in the air. It's going back and forth. There is a lot of political political controversy around what's happening at the border. And for political reasons, the administration has been trying to control the amount of people that are coming through the border because it hurts them politically currently. However, we'll see how it develops, with time. But at this point in time, they are still trying to control that southern border.
Okay, thank you very much. And yeah, this is something that a lot of people are asking at the same time, um, and they have questions because in the past we had the Remain in Mexico program,
Right.
but then that program was put on hold and now it has been reinstated. So is the Remain in Mexico program still rolling right now, or is not rolling at the moment?
I haven't seen any of the Remain in Mexico program being implemented yet, but that's a possibility because initially that was under the Trump administration where they started implementing that program. It was litigated in court whether or not it was lawful for the government to force people to stay in Mexico while their asylum application was pending in the United States. So that's why it was put on hold. But a lot of this is kind of a wait and see of how this administration is going to be approaching it in the next couple months, especially before the elections.
Okay, thank you very much. And don't forget, for everybody who has joined us today, the phone number that you can call is 216-279-3984, 216-279-3984. You can talk to one of the attorneys in the law firm of Margaret W. Woman Associates. Today we're talking with the attorney Nour Chammas, who is one of the experts in the asylum and withholding of removal cases in the United States. And recently I just noticed that so many attorneys are not filing asylums right now. Why is that?
I'm not sure why attorneys are not filing asylums. I mean, everything is on a case by case basis. So if, as an attorney, I get cases that want to file asylum or clients that want to file asylum, of course, you look into the facts of the case, whether or not they qualify under the law and whether or not they meet the requirements um, that are that are set forth in the law in order to file an asylum application. If they have no, if an attorney believes that a client has no real claim or has no colorable claim to file an asylum application, they may not file it on that basis. There's various reasons why an attorney would not file one, but I'm not sure exactly why other attorneys would not be filing asylum applications if somebody does qualify for it.
Okay, thank you very much for this answer. And we're getting our first question for today. It says, I have an IH on July 2025. I can't pay for an attorney because I don't have enough money. Would I get deported if I go without an attorney?
So you don't need an attorney to go to immigration court. I mean, you're not required to have an attorney to go to immigration court, but you have a right to return to obtain your own attorney. The government will not provide you with an attorney in immigration, unlike in criminal, where the government is required to provide you with representation. However, it's always preferable to have an attorney because you're dealing sometimes with a lot of complicated issues in immigration, and it's very difficult for a layperson to really fully understand it. So you may not have the full benefit of legal representation if you're representing yourself in immigration court. Now, normally the court gives people that are in immigration proceedings a list of attorneys who are either free or low-cost attorneys that might be willing to provide legal services. So I don't know if you've attempted to look into that or not, but the bottom line is you won't get deported just because you don't have an attorney, but you may be forced to go forward with your case. And, and if for whatever reason you don't meet certain requirements in your case, then you may be ordered deported because the judge would deny your whatever application you filed for. But that, if you don't have an attorney, that increases the likelihood that happens because you may not be able to fully and competently represent yourself.
Okay, thank you very much, Attorney Nour, for this answer. Don't forget that the phone number is 216-279-3984, 216-279-3984. Today, Ms. Wong is in the city of Nashville, but all of the attorneys are working really hard in each city that she has offices, and they are willing to help you out with your immigration case. The next question is, I am from Mexico. I am gay. I suffered a lot of bullying for being gay. Can I file an asylum for that based on that situation?
So, I would have to give a very general response. Obviously, each case would have to be independently evaluated. Now, generally speaking, if you are of a particular sexual orientation, that can be a basis for asylum. Now, generally speaking, in order to qualify for asylum, you have to show certain things. One, you have to show that either you've been persecuted in the past in your country, and if you have not been persecuted in the past, that you have a well-founded fear of future persecution in your country. The persecution has to be on the basis of one of 5 protected groups. Those are race, religion, national origin, political opinion, or membership in a particular social group. Now, being gay or anything based on sexual orientation is considered a particular social group under immigration law. So you would qualify on that basis, but you also have to show that the government is the one that is persecuting you, or groups that the government is unable or unwilling to control. That means you would have to show that if it's not the government or police or somebody representing the government that's harming you, you would have to show that the government is not able or willing to protect you. In the case of Mexico, it depends on the facts of the case. I know there's a lot of recent laws that have passed in Mexico that are very protective of the rights of the LGBTQ community, although the actual implementation of those laws is questionable, and people do still suffer persecution and discrimination in Mexico as a result of their sexual orientation. So, obviously, you would want to go talk to an attorney and present your case so the attorney can properly evaluate it, because everything has to be evaluated on a case-by-case basis. But generally speaking, you can qualify on the basis of sexual orientation for asylum.
Okay, thank you so much, Attorney Nour. Don't forget, the phone number is 216-279-3984, 216-279-3984. We have another question. Hi, my child has I-730 or I-130, I'm not sure, interview at the NVC. Before that, I petitioned for the same child after I became a U.S. citizen. Should my child honor the interview or ignore to wait for the I-130 to be approved?
So, okay, so there's a bit of a confusing question. Number one is, if you file an I-130 for a child that lives abroad, they're not going to have an interview for the I-130. Generally, the I-130 is approved or denied in the U.S. It's adjudicated here. You only have to prove that you are a U.S. citizen and that this is your biological, or even if it's adoptive, that's your legal child. You can do that by providing a birth certificate, and obviously, if you have proof of your U.S. citizenship, that's pretty much all you need to establish the relationship and the fact that you are a U.S. citizen. It normally would get approved on that basis. However, after the I-130 is approved, then the case moves to the NVC, which is the National Visa Center, which then organizes the visa application process. And then once the visa application and all the required documentation is provided to the NVC, then the file is referred to the consulate wherever that person is, and an interview is scheduled at the consulate. Now, obviously, you would need to go to that interview, or else you're not going to get your visa approved if you don't do that. But after the interview, if everything goes well, an immigrant visa would be approved. That person would get an immigrant visa, and they would be able to enter the U.S. as an immigrant at that time. So again, I'm not sure where you are in the process. If there is an interview, an immigrant visa interview scheduled for your child at their local consulate, then yes, they should go there.
So this person says that it's two petitions: is I-730 and I-130. I think it was a misspelling there.
I see. So the I-730 is a follow to join. So I'm assuming that you had an asylum application granted, but you're saying you're a U.S. citizen. So it seems like a lot of time has passed by. Normally, you have to file the I-730 within 2 years of having the asylum granted, unless you have some exceptional circumstance for why you couldn't file it during that time. But if you are already a U.S. citizen and your child is under 21, then it might be easier to go that route. I would have to look into your case more closely, obviously, but just generally speaking, I would say that if you've passed the deadline for filing the I-730, then I would suggest that you go through the I-130 process.
Okay, thank you very much, Attorney Nour. Don't forget, the phone number is 216-279-3984. If you have any other questions, please feel free to write the question down, or you can call for more information and to make an appointment with one of the attorneys at the phone number 216-279-3984. Next question is, hi, attorney. What does it mean that my asylum case was terminated? I will be deported?
So if you have a case in court, let's say, and you had an asylum application pending in immigration court, and this is happening commonly now because of a new policy, and your case was dismissed or terminated in court, then no, you will not be deported. So what happens is the only way that the government can deport you is they have to put you through the immigration court process. They have to give you a right to go before an immigration judge. Now, if your case in court is dismissed, then you're out of the removal process. That means the government is not currently seeking to remove you or deport you from the country. If they wanted to do that later on, they would have to put you back in immigration court proceedings. They could not just deport you. But I'm assuming that that's what's happening here. Otherwise, if you have an affirmative application with USCIS that was terminated for whatever reason, you wouldn't get deported just for that reason. But again, I would have to know more. I'm assuming that you're in immigration court proceedings. If that's the case, then you wouldn't be subject to deportation right now. If the government did want to deport you, they would have to put you back in that immigration court process.
Okay, and that's something that is very recent. The only thing is, correct me if I'm wrong, but I think they cannot file for a work permit anymore, right?
So if you don't have a pending application that allows you to qualify for a work permit, whether it's asylum or something else, then yeah, you can't file for a work permit. Once your case is terminated in court, that means you no longer have that pending application to allow you to continue renewing or filing for a new work permit. So you wouldn't be able to do that any longer. You would need to file either the same or another application and have it be pending in order to qualify for a work permit.
Okay, that's interesting. Thank you very much for this answer. Don't forget the phone number is 216-279-3984. 7 offices across the country: Atlanta, Chicago, Cleveland, Columbus, Nashville, New York, and Raleigh, North Carolina. And the phone number is just one. It's 216-279-3984. I entered on a B2 visa in 2013. I have 2 kids born in the US. Never filed asylum. Would it be bad to file asylum now? I am originally from Brazil. Thank you.
All right. So procedurally, you are required, in order to qualify for asylum protection, you are required to file your application within 1 year of entering the United States. If you don't file your application within 1 year of entering the United States, then you wouldn't qualify for asylum. You could qualify for a lesser benefit called withholding of removal, but you wouldn't qualify for asylum itself unless you can establish an exception to the 1 year filing requirement. An exception can be either extraordinary circumstances that prevented you from filing within the 1 year, or they could be changed country conditions or changed personal circumstances that gave rise to a current fear of returning to your country. So it depends on your case, obviously, whether or not you should or you would qualify for asylum if you filed it currently. In addition, we would want to look at your facts to see if you would have a colorable asylum claim in the first place. So no, it's not necessarily bad to file for asylum now, but you may not qualify for asylum depending on the facts of your case if you didn't file it within 1 year of entering the United States. Now, if you do file for asylum with USCIS and you do not establish an exception to the 1 year filing requirement, USCIS would have to refer your case to immigration court, so you'd be placed in removal proceedings. If your application is denied in immigration court, then you will be ordered removed to your country. So that's just something to think about when you're planning on whether or not you want to file for asylum.
Okay, thank you very much, Attorney Nour. And this is a very good experience to have an attorney that is specialized in asylum cases and withholding of removal, because he has most of the answers for your questions. So if you have any other question, don't forget that you can text us right now, and he will be answering for all of you the questions that you may have, or you can call the phone number 216-279-3984, and they will answer your call. They will set an appointment for you, and you will be able to talk to one of the attorneys in the law firm of Margaret W. Wong and Associates. My brother has been detained for 8 months. He had filed for TPS before going to jail. He came on a humanitarian parole and got in trouble with his roommates. He surrendered in front of the police, and then he was put on immigration hold. Now his TPS was granted, but he's still detained under the immigration hold. What do we need to do to bring him out of jail?
Okay, so when somebody gets arrested for a crime, normally the local police or local law enforcement will, if he doesn't have papers or documents or is not a citizen or resident of the U.S., will automatically report him to immigration, and they determine if they want to arrest that person. If you've committed certain crimes, then you may be removable from the U.S. or inadmissible to the U.S. So it's possible that Immigration and Customs Enforcement would have placed a detainer or a hold on you. That means that the local law enforcement would have to hold you for up to 48 hours to allow them to come pick you up. I don't know how long you've been in immigration detention currently, or whether the 8 months includes any criminal detention. However, and again, I'm not sure what this person is being charged with, or whether he's been convicted or not. So all these things are important to know. But ultimately, if you are placed in immigration court proceedings and you're in detention, then you can request to be released in exchange for a payment of bond. However, it also depends on the type of crime that you were convicted of, because you may be under what is called a permanent detention, which means that the government, the court would not have jurisdiction to be able to release you from custody at that point. So it's important to know like all the facts of the case. But it's possible, based on what you're telling me, that because of his criminal issue, that he's being held under immigration currently. I would strongly encourage you to contact us or contact an attorney to discuss that case, because it seems like there may be options for him, but we would have to see what exactly are the facts of this case.
Thank you so much for your answer, Attorney Nour. And we understand that some cases are very complicated, and especially these ones. Uh, it's just something that we need to learn. We cannot be violent in this country, because you are going to have consequences. And it doesn't matter where you come from. If you get into a fight, or you get into a situation in public, or even in your apartment. I learned a few days ago, attorney, that if you get into a fight with a roommate, that's domestic violence. I didn't know that. I just learned it like 1 or 2 weeks ago. So you don't want to get in trouble with the people that you live with, even if you don't know them. If you are sharing the same house, that would be domestic violence, and that's not a good thing to have in your record.
No, and it's actually is a ground of removal from the United States. So it's very important it's always very important to not break the law. But you always should think twice if you are either undocumented or you don't have residency or citizenship in the United States.
And something interesting that I learned recently is that if you have a gun, you cannot show the gun, or you cannot point at someone, just like threatening them, or just showing them that you have a gun, because that's penalized too.
It is. And if you have a firearms violation, it also is a ground of removability from the United States. So you keep all that in mind. One thing I would also say is a lot of people are lawful permanent residents. They become lawful permanent residents, and they kind of sit on their lawful permanent residence, and they don't apply for naturalization. So then they're lawful permanent residents for many years, and something happens. They get in trouble with the law. And then all of a sudden, now they're subject to deportation based on the criminal conviction or criminal charge that they face. Whereas if you're a citizen, you're protected. So I would always urge people, if you are a lawful permanent resident, as soon as you become eligible for naturalization, unless you have certain circumstances. I know some people don't speak the language, or they have trouble being able to pass a civics test. But otherwise, I would really encourage people to make sure that you become a citizen, so that just in case anything happens, you're protected as a citizen. As a permanent resident, you're still subject to deportation. So just keep that in mind.
Thank you very much, Attorney Nour. And I think we have one more question, and we have time for one more question. So I'm going to read it now. I was deported back in 2021. I have a 5-year-old daughter born in the US. She has Down syndrome. Is there a way of relief for me and her mom? I have been deported twice, and mom has a removal order, but never deported.
Okay, so if you were in removal proceedings and you had been living in the US for more than 10 years, and you can show exceptional and extremely unusual hardship to a US citizen daughter, if you were to return to your country, then you would qualify for something called cancellation of removal. And that ultimately would get you a green card. In your situation, if you actually have been physically deported twice after an order of removal, you likely would not qualify for that anymore, because there's no way to even reopen your case at this point. Although, again, I would have to look more closely into the facts of your case. So in situations like this, it's always important to consult an attorney. As far as the mom is concerned, you said that she has a removal order but was never deported. There's always a possibility that she can, again, based on the facts of her case, that she can file a motion to reopen her case with immigration court. And if she does, then at that point, she may become eligible. Again, depending on a lot of other factors, but I'm giving you very extreme generalities here. She might become eligible for that relief, cancellation of removal. And if you do have a 5-year-old with that condition, then that's the type of condition that is considered to establish the required exceptional and extremely unusual hardship to a qualifying relative when filing that application. So again, this sounds like there's a lot of complications in it. So I would, again, strongly urge you, we would be happy to look at it, but strongly urge you to consult with an attorney because it's very difficult to tell you exactly what you should do when I don't know exactly what the facts of your case are.
Yeah, and okay, let's say it's more complicated for the dad, but what about the mom? She has a removal order, but she has never been deported.
Right.
So if she has over 10 years living in the United States, and this daughter has Down syndrome, is there any way of relief for the mom at least?
It's possible. It depends on a lot of things. One of the things that I would need to look at is, for example, when she was originally put in immigration court proceedings, the notice to appear that she obtained, did it have a date and time on it, or did it not have a date and time of a hearing? Because that can make a difference as to whether or not she can establish 10 years. Because when in order to qualify for cancellation of removal, you have to establish that you've been in the United States for at least 10 years before you were placed in removal proceedings. So if you're placed in proceedings and the date, let's say, of your NTA, the notice to appear is, let's say it's December 1st, 2010, and you entered the United States in 2001, then you could not establish 10 years of physical presence in the US. You would not qualify for cancellation of removal. However, because of the 2021 Supreme Court case, which said that if that charging document has no date and time of a next hearing, then the clock that counts the time that you're in the US doesn't stop, then it's possible, even if you reopen the case later, that you can establish 10 years at that point, because throughout that entire time, that clock never actually stopped. That clock continued to run. But again, and she would have to have a basis to reopen the case. So there's a lot of complexities even in her case. But if she were theoretically able to reopen the case and she didn't have a date and time on her NTA, she doesn't have any other issues, then yeah, it's possible that she could qualify for this relief at that
Okay, thank you very much, Attorney Noor. Our time is up for today. So thank you so much. More questions coming in, but if you want to talk to the attorneys right now, the phone number is 216-279-3984. Make your appointment in any of the 7 cities that they have offices in Atlanta, Chicago, Cleveland, Columbus, Nashville, New York, and Raleigh, North Carolina. And the phone number is just one. It's 216-279-3984, 216-279-3984. Over 60 people working for you and over 15 attorneys working for you with over 47 years of experience. Thank you very much, Attorney Noor. Have a good lunch and see you next time.
Thank you. Thank you.
Thank you. Don't forget, the phone number is 216-279-3984, 216-279-3984, attorneys in the law firm of Margaret W. Wong.